Advocate Chauke. Advocate Mashamayane, you will proceed, but my sister is going to deal with a few questions in conclusion, and you will then take it from where she ends, or rather where you ended yesterday. Advocate Batohi, you are still under oath.
I do, Judge.
Thank you. Advocate Batohi, I think the last question that I asked when we adjourned related to the opinion of Advocate Nalani.
Yes, that's correct.
That is, we were at a point when I was talking about whether you had read the opinion or not, and you said you had.
That's correct.
And you said you also observed the shortcomings in the opinion, right? And those shortcomings that you observed in the opinion, what did you do with them?
Well, at that point, we had obtained the report, and I think I need to go back to my affidavit that deals with what happened after that, so that it will address the question. And I can also contextualize it because I am trying to cast my memory back a number of years. It's my affidavit. I think it's around where we have been for the past couple of days. We're dealing with the process for the referral. It's on paragraph 165 at page 70, Chairperson. It's in my affidavit.
Yes.
So Chairperson, I had looked into those matters. I had got Advocate Nalani's report. At that point, the Zondo Commission was doing its work. And I had really hoped that the Commission would complete the piece of work relating to the capture of the criminal justice system, including the National Prosecuting Authority. And the Commission will make findings with regard to the proprietary or otherwise of people within the NPA. And so when I received the Nalani report at that point, I didn't do anything with it. I waited for the Zondo Commission, and it completed its work. The Nalani report was in October of 21. The Zondo Commission completed its work the following year in April. Well, that was the final report that was delivered in April. I realized then, very disappointingly, that I was hoping that the Commission would make findings either clearing NPA members or finding that there's some impropriety, in which event I would be able to decide what to do with it. But the Commission didn't go into any of that, and apparently due to my understanding is timeframes, etc., time limits and budgets, etc. I don't have first-hand knowledge of this, but it's what was available publicly. They did not make any findings, either for or against. I was then in a situation that I had to think about, what do I do? I had the Nalani report, the opinion at that point. And so in July then, I sent that opinion to Advocate Chauke of 2022. That's in paragraph 168 of my affidavit, and asked him to provide me with reasons why I should not request the president to establish an inquiry into his fitness to hold office. And my letter is attached. So to answer your question, at that point, that is what that was the process that was followed after that.
Okay. So when you sent the copy of the opinion, you had already picked up their shortcomings, or did you pick that up later?
I mean, he had mentioned it in his report, so I would have been aware of certain shortcomings at that point.
Right then, thank you. That concludes my questioning. Okay.
I take note.
Yeah, just understand that when we ask questions, you ask questions in order to get, at times, even a holistic picture of what has been happening, so that at the end, when you are sitting in your office or elsewhere, we should be able to carry out our mandate to finally.
I think at this rate, I will retire in this commission in the end of January.
Well, that's all. Thank you.
Thank you very much.
Before you begin, Advocate Mutsamunyane, just bear with us. We have taken a bit of time to clarify a few aspects since this morning. How did this matter of the Katomena land the Zondo Commission? Is my reading correct that Advocate Boyce, or rather Major General Boyson, is the one who complained to the Zondo Commission based on allegations of state capture of a certain member of executive, certain minister?
Chairperson, I cannot say how it landed on the Zondo Commission table from first-hand knowledge. I can, what I am aware is that about this case is that it emanated in KZN. There was a case against a person called Toshan Pandey, who's a businessman in KZN, and that case. There were allegations in that case. The case is currently in court. He's been charged subsequently. That case in KZN was against Toshan Pandey, and the commissioner, the provincial commissioner of police at the time, I can't recall the name, was also, if I'm correct, one of the accused. I'm not sure, but there was also a police officer, and General Boyson was investigating that Pandey matter. He was the investigator, and the matter was there were allegations, and I'm sure he'll be able to testify a lot more to this. There were allegations that Pandey was connected, highly connected, and that the investigation by Boyson was not seen in a favorable light and had to be stopped. The charges against Pandey were subsequently withdrawn in KZN by Advocate Noko. And I should say that I even wrote to Advocate Noko and asked her for various reasons for various decisions. And I was at the point of referring that matter to the president when she resigned. But the Pandey matter was kind of central to this, and the allegations of connections to high-placed politicians and Boyson's involvement in that investigation. That I know, and I'm sure there'll be evidence presented to that effect, but how it exactly got to the commission And who took the complaint there, I can't say.
How Advocate Chauke was called to make statements before the Zondo Commission?
I'm not aware of that, Chairperson.
You're not aware of that? I think it may be when Advocate Chauke testifies, because when I read his statement, it appears that he was asked to appear before the Zondo Commission, and he subsequently made a statement, but that's a matter for another day.
Thank you, Madam Chair. Advocate Batohi, you will remember that yesterday we ended up at paragraph 179, where reference is made to Hali SC's and Wenzel's opinion.
That is correct.
Now, when you were being asked questions for clarification, it emerged that there was an annexure attached to Advocate Hali SC's and Wenzel's opinion.
There were a couple of annexures. I can't remember exactly how many.
I'm specifically referring you to the annexure, which was an affidavit of Colonel Kubo's Dimeye rule of set.
That is correct. I did mention that in my testimony.
Now, may I direct your attention to, before we revert to the annexure itself, to LO, it's LO4 bundle, in which Advocate Hali's and Wenzel's opinion appears.
The page number?
The page number is LO001049. In other words, 001049.
Yes, I see that.
Before you get to the annexures, to that council. Yes, indeed, we were at paragraph 179, and my recollection is that my sister Ramachacha was asking you a question about the third sentence of 179 that reads, they did so and concluded that there was a sufficient basis to include Advocate Chauke's conduct in the Mdluli matter in the recommendation to the president, a post there. But the point that she was making, and I would like you to clarify it for me, relates to the sentence itself. They did so and concluded. When you testified, you inserted I concluded that there was a sufficient basis. The insertion from your evidence does not appear in the sentence itself, and this may be the question of semantics. I run ahead of myself and say it may be a question of semantics, because when you say they did and they concluded, shouldn't the sentence read as follows? Anyone who reads it like that will probably say, they did so and they concluded, because you refer to they. And you said yesterday, they did so and you concluded, and I concluded. Would you clarify that for me?
Yes, thank you, Chairperson. I thought I clarified it yesterday. I will repeat what I said and what I recall I said. When the question, when the evidence leader took me to this paragraph, he said to me not to read it verbatim, but to talk to the paragraph. That is the way I understood it. And that is what I was doing. So when I said they did so and I concluded, I was not inserting anything anywhere. I was speaking about what happened after this report, this opinion was obtained. So it's not, so to be clear, I was not reading, I was talking, and that is why I mentioned it like that. And then I was questioned about it by Madam Ramahaha about the inclusion of the I, and I said that, and that is in fact the position, Chairperson. Yes, that's correct. Chairperson, yes, I was asked this question as well yesterday, and I said it should read, they did so and concluded. That would mean the conclusion is talking about the authors of the document, the way it's framed here. It would mean they did so and they concluded that. Well, that's, yes, that's from the context.
So it is the authors of the opinion who made a conclusion.
That's what appears from there, Chairperson.
No, Counsel, in fairness to us and yourself, this is your affidavit.
That is correct,
And
Chairperson.
it cannot be like we are forcing you to say something that you have not said. You said this under oath, and I'm asking you to clarify what appears from your own affidavit. If there is an insertion of I, if there's no insertion, it's understandable. But my reading of that sentence is that the people who wrote an opinion concluded, and you are saying that's exactly how it should read.
Chairperson, I must read that opinion again carefully to make sure that that is what in fact they concluded, because I'm really trying to, these affidavits were put together very quickly. I tried to explain. We stayed up till midnight on the Friday and uploaded it at 10 to 12 at midnight, the day it was due. So we went through it really quickly. We wanted to adhere to the very strict timelines. And so I would want to read that opinion again before I say that that is in fact what they concluded, because that is, I have to read it before I say conclusively that is what they concluded.
Adv Batohi, let's not go around seconds, please. This is your affidavit under oath.
That's correct.
And you know, as a lawyer, what that means.
I do.
We are addressing the contents of your own affidavit. It may well be that it was prepared in haste. But when you append your signature under oath to the document, it means you believe the contents of what you are saying in that document.
That's correct.
Now I'm saying to I beg your pardon. I will try to capture what I said earlier, that this is your affidavit under oath, and we need clarity on the contents of this sworn statement about paragraph 177, line 3. What I want to ascertain from you is whether we should read this sentence as it appears, that open quote, they did so and concluded If my reading is correct, it means they who prepared that opinion then made a conclusion, not that it is you who concluded.
Chairperson, that's the way it reads. And that is, in fact, the way it reads.
That's what it is.
I'll have to read the report again to make sure that is what it is.
No, Council. That's what it is, that they did so, the authors of the opinion did so, and they concluded that there was a sufficient basis, blah, 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 blah. This is what they concluded, not that you concluded.
Chairperson, as I said, when I prepared this affidavit, I'll be honest with this court, I didn't read any of the annexures. These annexures have been read by me years ago. We prepared this under extreme haste. I did not read any of the annexures. I've been reading them subsequently to try to prepare. And that was the position when I signed this affidavit. And I agree, it reads as they did so and they concluded that there was sufficient basis. But I will have to look at it to make sure that what I signed to was in fact, accurately captured.
Council, it is helpful to be very, very concise and not end up saying things that you don't want to say. When you say you did not read this document, it may mean a lot of things. So please just answer the question and not elaborate on what I'm not asking for, because it's a simple thing. Should we read the sentence as it is, or do you want to correct it under oath? Because you are still under oath. Yesterday, a question arose as to whether, and I'm asking this for the last time, whether it is you who concluded, it's just as simple as that, or whether it is the author of the opinion or the authors of the opinion who made a conclusion.
Chairperson, firstly, I want to clarify, I read my affidavit.
I know
and I signed it. Yes.
The question is it you who concluded or the authors who concluded based on this sentence?
Chairperson, the reason why I'm emphasizing I read my affidavit is because the chairperson said that I did not read documents. So I wanted to make sure clear that I read the affidavit, but not the annexures.
It is you who earlier on said that you did not read the annexures.
That is correct. So I wanted to clarify it's only the annexures, not the affidavit. Chairperson, on your question, yes, I do say in my affidavit, they did so, and as it reads, they concluded that there was sufficient basis, but I will have to read the annexure again to make sure that that is the correct, that what I put there is in fact accurate. I can't correct it now. I might ask to correct it at a later stage if it is indeed incorrect. But at this point, I don't have any reason to think it would be incorrect.
I don't know how you correct some statement you made under oath, because you bound yourself to the correctness of that because you signed it under oath, but that's a matter for argument.
Chairperson, I did explain the circumstances.
You may proceed, Advocate Mutlamunyan.
Chairperson, I did explain the circumstances under which we signed this affidavit. They were really tight time constraints.
May we proceed, Council?
Thank you, Madam Chair. Advocate Batohi, I was referring you earlier to Advocate Hali SC's and Wenzel's opinion, and I said it's contained, it starts from from page 001047, and I specifically refer you to paragraph 5, on page LO 001049, where the authors of the opinion deal with the summary of the crucial conclusions against Advocate Chauke. Do you see that?
I do.
I'm doing this for the simple reason that you were asked as to whether you considered any evidence before you could refer the matter to the president. Now, before you answer that, please read paragraph 5 into the record.
I will. Before delving into our process of reasoning and the evidence to support that reasoning, there are preliminary facts and observations we should set out to better understand what is to follow. These are all derived from the affidavit of Colonel Kobus de Meyer Rulofse, who had investigated the charges against Lieutenant General Mdluli. We attach a copy marked A.
Now, when you referred the matter,
I beg your pardon, Counsel. Where are you reading? Are you at Advocate Halley's opinion or at 01047 to 1 LO 0149?
Madam Chair, we are on 001049, specifically at paragraph 5 thereof.
LO
LO4,
LO4.
yes, page LO 001049. That's where Advocate Batohi had just read.
Yes, thank you.
May I proceed?
You may proceed.
Now, when you sent the referral to the president's office, had you taken note or had you read, so to put it, this affidavit?
Yes, and the other annexes as well, but yes.
And the
I
other
did.
annexes as well.
Yes.
Was this affidavit containing the evidence that you said you took account of?
Yes, a summary of the evidence.
Now, Madam Chair, that affidavit is part of the record. It is contained in bundle RM3. On page, it starts on page RM 00748. It is a very lengthy affidavit which ends on page RM 00814 and deposed to by Kobus de Meyer Rulofse, Colonel Rulofse, on the 5th day of April 2012. It will be marked as an exhibit, Madam Chair. It's already on the record. It will, in due course, be marked as an exhibit.
Yes, thank you.
Now, in the course of questions that arose from the panel members, the issue of provisional withdrawal as against a withdrawal was dealt with. Now, you may want to perhaps clarify what it really means. And in this regard, in order to clarify what it really means, what provisional withdrawal of a charge or charges as against a withdrawal, you can go to Branch JA's decision. Or
Beg your pardon, I'm trying to link that question to the statement of Colonel Rolofse. Is it linked or is it separate?
It's a
question?
separate. We're done with the issue of Colonel Rolofse, Madam Chair.
Yes, you may proceed.
Go to CL on page 368, where you'll find the judgment of Branch JA. CL2. Are you there on page 368? And reference is here made to paragraph 34.
I am.
Right. Continue to read paragraph 34 into the record in order to explain provisional withdrawal as against withdrawal. Paragraph 34
of the SCA judgment.
Of the SCA judgment, that's Branch JA's judgment, and it's on page CL 00368, and the bundle is CL2.
Yes, thank you.
You may proceed.
Thank you. Chairperson, I did explain that there was no real difference between, there was the effect of a provisional withdrawal and a withdrawal was the same. I'm going to read what Branch JA says about that into the record. At 34, he states, the withdrawal of charges by Mkhwebi and Chauke, so the NDPP's argument went, was covered by Section 6A and not by 6B. In consequence, so the argument proceeded, these decisions were only provisional and therefore not subject to review. Although I am in agreement with the premise of the argument that both decisions to withdraw were taken in terms of Section 6A, my difficulty with its further progression is twofold. The first, I see no reason why, at common law, a decision would, in principle, be immune from judicial review just because it can be labeled provisional, however illegal, irrational, or prejudicial it may be. My second difficulty is more fundamental. I do not, and this is the important part, I do not believe a decision to withdraw a criminal charge in terms of Section 6A can be described as provisional just because it can be reinstated. It would be the same as saying that because a charge can be withdrawn, the institution of criminal proceedings is only provisional. As I see it, the withdrawal of a charge in terms of Section 6A is final. The prosecution can only be recommended by a different original decision to reinstitute the proceedings. Unless and until it is revived in this way, the charge remains withdrawn. Thank you. That is my understanding as well. I should say that
On
is the
this
position.
reading, if I may clarify, that which the SCA says in this paragraph, does it mean that a withdrawal which is final, does it bring to an end the prosecutorial decision, or rather the prosecution, if I may put it that way? In other words, I'm not sure whether I'm putting it clearly for you to understand. Bringing a matter to an end in the form of saying nolle prosecute or not prosecuting, a decision to prosecute or not to prosecute. So I'm using those concepts. Whether what Branch JA says in relation to the withdrawal being final, is it akin to saying a decision not to prosecute or bring prosecution to an end? Because it can either be prosecution or not prosecuting. So if you withdraw, does it mean that it is the end of that matter?
Chairperson,
In the sense that it is not going to be prosecuted. It has been brought to finality.
Chairperson, it does not mean that, and that is not, in my understanding, what Brunt JA is saying. It is final in the sense that it remains withdrawn until you decide to institute the case, reinstitute, re-enroll. That is correct, Chairperson.
Thank you for clarifying that. You may proceed.
Thank you, Madam Chair. We will then leave that aspect and go to the issue of delegations of authority. Remember, you were being asked as to who has to issue out delegations when prosecutors straddle, go to another jurisdiction. Now, there are delegations issued here, and they're not part of the record, not so.
That is correct. Oh, I'm not sure if they're not part of the record, but I know there are delegations that you have.
Oh, my apologies. They are part of the record. They are part of the record. And let's go to B1, page 00144 to page 00145. Madam Chair, they will later be
Helpful if you tell us the volumes. What volume is that?
It's volume B1. Yes.
Volume B1.
On page 144B, 00144 is the delegation of Silot Leston Maema by Advocate Nomngobo Jiba. And on the next page, B00145, appears the delegation of Kulelani Raymond Matenjwa by Advocate Nomngobo Jiba. They will later be be marked as exhibits, Madam Chair, but they are on record. Are you having them in front of you?
Yes.
Can you confirm?
Yes, I can confirm that.
Okay, please confirm that on page 144 and 145.
I do.
Now go to page, still on B1, 00470. Are you there?
Yes.
It's a delegation.
Sorry, 004?
470.
It's 469 as well.
Yeah, start with 469.
Mm-hmm.
We're starting with 469. 00469 B1. My apologies, it's B2 actually. B2, Madam Chair, and Madam Aloy 469 in B2.
I know that you refer to these letters as letters of delegation. The Act speaks of authorization. Is it, shouldn't we stick to the letter, to the word used there, or in the letter itself? It's authorizing.
It's authority, yes, authorizing.
Because it may well be an issue whether the DPP has the powers to delegate. It's another matter. But let's use the wording used in the letter. Even in the heading, they use authorization.
Yes, that should
I
be.
see you refer to them as delegation letters.
Loosely like that, but you're correct, Madam Chair. They should be referred to as they appear in the Act and in the document itself. Let's go back to 00144. The authorization by Nomnqobo Jiba to Selot Leston Maema to exercise the powers in section 21 in KZN. Can you confirm that?
I do.
Go to the next one on page 145, B1, page 00145. That is the authorization by Advocate Nomnqobo Jiba to Kulelani Raymond Matenjwa.
That's correct. And they are both dated the 8th of March 20. They are both dated 8th of March 2012.
Now, let's go to the next one in B2, bundle B2, page B, 00469, being the authority to institute and conduct criminal proceedings by Cyril Simpiwe Mlotshwa to Mahlubi Ntlakaza. Can you confirm that?
That's correct.
What was the date?
5th of June 2012.
It's not the first.
It's with effect from 1 June 2012, but it's dated 5 June 2012.
Okay. Proceed to the next one on page 470, B00470. In B2, 00470, whose authority is that?
Patience Moleko, granted authority by Cyril Simpiwe Mlotshwa, the acting DPP of KZN. Also dated 5 June, the authorizations from the 1st of June.
The next one on page,
Who is Ntlakaza?
the question from Madam Chair is who is Ntlakaza, Mahlubi Ntlakaza?
I can't recall. I'm not sure if he was one of those. He was part of the team under Advocate Maema, but we can check the document.
The prosecution team under the leadership of Advocate Maema.
Yes, I think his name was also there in the list.
Is he a prosecutor, director, or DPP? What is he? Mahlubi?
Definitely not a DPP. I don't know what his rank would be. Below, it will be below that, either prosecutor, senior, or a deputy. I'm not sure.
Do you know from which province is he from?
No, Chairperson.
Madam Chair, maybe for convenience and for cross-reference, their names, the names of the Katomana team of prosecutors appears in bundle S in annexure SB3, which is the internal memorandum of Advocate Dikok and others. Their names appear there. The team's names appear there. It's not clear here. It's only stated as Advocate Mahlubi. Advocate Mahlubi Ntlakaza. It ends there. But we know, Madam Chair, that Advocate Selo Maema, evidence has been led here that he was from Northwest Province.
That's the only one we know. That's the only one we know that he was from outside KZN, by virtue of the fact that certain crimes were committed in the Northwest. That's why, Council, I'm asking you about Advocate Ntlakaza. Was he from KZN or was he from elsewhere? You will let us know at a later stage.
Chairperson, if I may, none of these colleagues could have been from KZN because they were all being granted authority to prosecute in KZN. That means they are not KZN prosecutors.
My colleagues are advising me, Madam Chair, that Advocates Matenjwa, Ntlakaza, JJ Mlochwa, Pumeza Futani were all from South Gauteng. Except Futania, that's right.
Even Advocate Mlochwa?
Yes, JJ Mlochwa.
JJ.
There's another Mlochwa, not the other one from KZN.
Yes, I know that.
Yes. And Futani was also from Gauteng. But not South Gauteng.
Thank you. It helps. Councillor.
Thanks, Madam Chair.
Chairperson, we need to clarify that and check that it wasn't South Gauteng.
About
My
which one?
understanding is that the four of them might in fact be from South Gauteng, but that can be easily clarified.
Including Futani.
Yes.
You may proceed.
Now, go to the next page, Advocate Batohi, where you will find authorization by Advocate Cyril Simpio Mlocha to Pumeza Futsani. Do you see that?
Yes, I do. It's the same authorization dated 5 June with effect from 1st June 2012.
The same,
Authorization to conduct prosecutions in KZN.
yeah, in the same bundle before, go to the next page, 00472, where you'll find authorization by Advocate Mlochwa to Advocate Jabulani Mlochwa. You see that?
I do. It's the same authorization and the dates are the same. And signed by Advocate Mlochwa, acting DPP KZN.
All these were authorizations to institute prosecutions in KZN
That is correct.
by prosecutors who were not stationed in KZN.
That is correct.
From another jurisdiction, in this case, South Gauteng.
Yes, that is correct.
Madam Chair, maybe to get clarity on this, on Futsani, I am informed that Futsani was at the time the chief regional court prosecutor in the magistrates court, I believe Johannesburg. And Futsani, I'm told, was a lady.
Advocate Nkabinde, you've just said they were all, these are authorization for all these members who were all from South Gauteng, but earlier on you said some were not from South Gauteng. Has that been
All but
changed?
one.
All but one.
Yeah, all were from South Gauteng. There's only Maema, Advocate Maema, who was from Northwest. Now, another point of clarification is that Miss Futsani was a lady who was a chief regional prosecutor at the Magistrates Court, Johannesburg. Now, these authorizations will later be marked in due course, Madam Chair, as exhibit.
Thank you, Council. You may proceed.
Advocate Batohi, we now leave the issue of authorizations and get on to before we leave them. Is the validity of these authorizations in issue?
No, they aren't. I mentioned in the testimony that they had received, these prosecutors had received delegated authority to prosecute in KwaZulu-Natal, either by the DPP or by the National Director, and this confirms that.
What is in issue exactly?
Is the fact that Advocate Chauke had no authority to exercise powers in KZN.
Now, let's leave that aspect and get onto the next one, which is the issue of evidence or no evidence, as you stated in your evidence. You have been asked questions in clarification about evidence or no evidence. Now, you'd want to clarify that position, that issue, by getting to the report of the internal memorandum, rather, of Advocate de Kock. Is that correct?
That's correct.
Now go to your paragraph 182 before you do that. Your paragraph 182 of your affidavit. You may read it into the record.
Ultimately, what struck me is that in the Boyson matter, Advocate Chauke had vigorously pursued criminal charges against Boyson when there was, as found by the High Court and in my assessment, no evidence against Boyson. And this is the aspect that I want to clarify. I continue, but in the Mdluli matter, had adopted the opposite stance and declined to prosecute, instead referring the death of the victim in that case to an inquest when there was strong case against Mdluli. I do know the chairperson asked me about this particular paragraph, and we will deal with it now.
Go to SB3, Annexure SB3.
Let's get the correction. I did not ask about these paragraphs. I was asking about the terms of reference, in which you find a common thread of the allegation that Advocate Chauke did what he is alleged to have done when there was no evidence.
Right.
Now, that common thread runs through the terms of reference in relation to the allegations leveled against him. You might have wanted to answer that question in relation to this paragraph.
Thank you. Thank you, Chairperson.
Go to go to the DCOC panel internal memorandum, which is SB3 in your,
Are you done with paragraph 182?
it's linked to what she's going to explain, the no evidence, insufficient evidence issue. And
You are going to a new matter?
no,
It's linked to
it's
this.
linked to it. It's
Thank
linked
you.
to paragraph 182.
Yes, thank you. Which paragraph now?
We are now getting to SB3, Madam Chair, to which I've referred Advocate Batohi.
Page number?
SB3, go to page 153.
You can tell us what the document is.
The document is an internal memorandum by Advocate DCOC and others and his team, which starts on page 134.
Thank you.
Are you on page 153, Advocate Batohi?
I am on page 153.
Maybe before you go to 153, let's
Maybe
go to
152.
first go to 152.
Yes, that's correct.
Under paragraph B, where the panel deals with the legal position in respect of racketeering prosecution.
That's correct.
Read that into the record, and
So,
thereafter
Chairperson,
you can explain whatever you wanted to explain in regard thereto.
so Chairperson, to contextualize, I had been asked about whether there was no evidence, and there was a discussion around no evidence and insufficient evidence. And I wanted to clarify that my evidence that there was no evidence relates to charges to support the charges of racketeering. And I want to explain that now. So if we from page 152, paragraph 63, that's SB3, paragraph 63 first, that part deals with that section in the document is headed legal position in respect of racketeering prosecution. And then the subhead is the nature of the crime of racketeering. Paragraph 63, criminal law target perpetrator. The crime of racketeering as defined in POCA focuses on the enterprise and objects rather than on the perpetrator. Racketeering is a complex crime which bears some resemblance to the common law crime of conspiracy. It usually involves group activity. In South Africa, for a person to be liable under Section 21E of POCA, he or she must participate or be involved in at least two underlying offenses listed in Schedule 1 of the Act. 65, the offense consists not in the commission of an act such as stealing, but in the membership of an organization which has been shown to have committed at least two particular offenses. The focus is on the relationship between the accused, the enterprise, and the pattern of racketeering activity. And then the next subhead deals with the offense of participating in the affairs of an enterprise, which is Section 21E of the POCA, Prevention of Organized Crime Act. And then the panel sets out in paragraph 66, 67, 68, essentially what this offense entails, that is participating in the affairs of an enterprise. And if we look a little further down, 66, the accused is guilty by virtue of being involved in an enterprise and being involved in the commission of two or more offenses. And 67, they set out factors that would be taken into account to determine a pattern of racketeering activities. And the factors are listed there. I won't list them. In paragraph 69, The panel looks at what the pattern of racketeering activity requires, at least 2 acts of racketeering activity. It has been held in several cases, US cases, that a mere existence of multiple acts of racketeering may not be enough. The criteria are that the acts must amount to or pose a threat of continued criminal activity. Paragraph 17 deals with the elements of this offense of participating in the affairs of an enterprise in terms of Section 21E, and that is set out: an enterprise existed, the accused managed or was employed by or associated with the enterprise, pattern of racketeering activity existed, the accused directly or indirectly conducted or participated in the affairs of the enterprise through a pattern of racketeering activity.
71.
Well, the
Deals
next
with?
subsection is the next offense, and these are the 2 offenses that the authorizations of Advocate Jiba and Advocate Abrahams related to. Section 21F is the offense of managing the enterprise in terms of poker, and Section 71 states managing the operation or activities of the enterprise is the offense. Here, the target is the manager. It must be shown that the accused occupies some kind of management position in the enterprise. 72 deals with the elements of this offense of management, and those are set out in that subsection. I won't read it in detail unless I'm required to.
You don't have to.
And yeah,
Yes, is there anything that you want to?
no,
No.
that's just in brief what the these offenses actually entail.
Now, having in mind what you set out in paragraph 182 of your affidavit, when you say, and in my assessment, no evidence against poison, can you explain this concept, no evidence,
Yes,
vis-a-vis racketeering charges?
yes. So that is the position. I concluded that, and looking at the evaluation that was done by the panel, and bearing in mind also that Judge Govan also found that there was no evidence to support racketeering charges. But on the base of the evaluation in this report, which starts at page 157,
In paragraph 77.
77, they state the evaluation of the evidence in the docket will be done in accordance with the principles of the law discussed above, some of which I had just referred to a moment ago. They then proceed in the paragraphs that follow with their evaluation of the evidence.
The next one is paragraph 82, if you go to that one.
At paragraph 82, they state, we also read and analyzed the evidence in the 23 dockets that the prosecution team, in their PowerPoint presentation to Abrahams, said implicated the accused in racketeering activities. It appears based on analysis of the 2, sorry, let me start again. It appears based on an analysis of the 2 indictments that formed part of the documentation Jiba and Abrahams considered, that no further dockets were added or removed. Table 3 refers to these dockets. And if we turn the page at 160, Table 3 is the list of the 23 dockets that they considered in this matter.
Now, go to paragraph 83. You don't have to read it, just the content.
Paragraph 83, we will discuss the content of the dockets and in particular some of the challenges in the investigations. In the discussion on the racketeering investigations, reference will also be made to incidents that traversed a period of 4 years from 2008 to 2011. It should be noted that the bulk of the racketeering events occurred between 2008 to 2009, whilst in 2010 there were only 3 events, and in 2011, 2 events. Durban North CAS 67-7 of 2011, CAS 69-7 of 2011, and CAS 71-7 of 2011, referring to 1 moving crime scene. And those CAS are police dockets, those CAS numbers.
Go to SB3, page 228, paragraph 246.
(246), you said?
Paragraph 246, Madam Chair. Are you there,
Yes,
Advocate
I
Batohi?
am.
Read paragraph 246 into the record.
So just in terms of context, what followed from what I'd read up until this point in the report is an analysis of all the evidence, of the statements of witnesses, etc. And in 246, they state, in respect of both sets of authorizations, a proper case for racketeering was not made out on the papers presented. That is their conclusion.
Are you then able to
Yes, on that, it was on the basis of this.
explain that?
And also on the basis of the judgment of Gorvin, and looking at the evidence that was presented there, that I concluded that there was no evidence to support racketeering charges.
Go to paragraph 274.
Sorry, in the
In
report?
SB 10.
Oh.
What volume is that? What volume is that?
That is one of the annexures to Advocate Batohi's
Thank you.
affidavit,
SB 10.
SB 10.
Are you still on the point of the no evidence? Or in relation to something else?
We're still in the no evidence issue, Madam Chair.
SB 10 page.
Page 274. And the contrast between the Mdluli and matter and the poison matter. Are you there, Advocate Batohi?
I am.
Just describe this document. It is the letter by Advocate Batohi to Minister Lamola, correct?
Yes, it is a ministerial memorandum to Minister Lamola, Minister of Justice and Correctional Services, from Advocate Batohi, which is a request to institute an inquiry in terms of the MPA Act.
Thank you.
Can
you read paragraphs 24 and 25 into the record?
Yes, I will certainly. But before that, Chairperson, to answer your question about the no evidence aspect, to be clear, Chairperson, what I'm going to read now speaks to the entire paragraph 182, where I say that Advocate Chauke had vigorously pursued criminal charges against Boyson when there was, as found by the High Court and in my assessment, no evidence against Boyson, but in the Mdluli matter had adopted the opposite stance and declined to prosecute instead of referring the death of the victim, etc. So the point I make, Chairperson, is I'm referring to this part to also addressing that stark contrast in Advocate Chauke's assessment of these two matters. If I may proceed, Chairperson.
Before you proceed, let me look at your paragraph 182. No, understand. And this memorandum to the minister also part of it addresses this very point.
It deals with the same point, Chairperson.
You may proceed.
Thank you, Chairperson. paragraph 24, I state that the Cato Manor and Mdluli matters were all part of a much larger complaint of state capture leveled against several prosecutors, including Advocate Chauke, and dealt with before the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state, in brackets the State Capture Commission. Unfortunately, the State Capture Commission was unable to complete its inquiry into the state capture of the NPA. Paragraph 25, the significance of the Cato Manor and Mdluli matters is above all to be found in Advocate Chauke's starkly contrasting actions and his exercise of decision-making powers in dealing with the two matters. A, it is apparent that there was no evidence to support the racketeering charges in the Cato Manor matter, yet Advocate Chauke and the prosecution team seemed to be determined to institute charges against Major General Boyson, and did so with great vigor, committing various breaches of the prosecution code of conduct in their efforts to do so. I should add it should have included the Constitution as well as the NPA Act, prosecution policy and directives. B, this must be contrasted with Advocate Chauke's handling in the Mdluli matter, in which there was a strong case against Lieutenant General Mdluli, yet Advocate Chauke appears to have been at pains to avoid prosecuting him. At 26, it is important to note that these apparently contradictory stances were adopted at approximately the same point in time. It was around this time that the fraud case against Lieutenant General Mdluli was also withdrawn in the NPA. I'll stop there, Counsel.
Now, you have dealt in a nutshell on what you are now stating in your paragraph 183. Paragraph 183 of your affidavit.
Yes, that's correct.
Go to paragraph 184. Of your affidavit.
Just a moment.
Paragraph
184.
Yes, I'm there.
Proceed to read it into the record.
Perhaps I will read 183 as well. I considered Advocate Chauke's versions in relation to the Boyson matter and the Mdluli matter. I've outlined his defenses in respect of both of the matters above. I was satisfied that his version in respect of the Boyson matter was untrue. As explained above, there was ample evidence to suggest that he acted as the de facto DPP of KZN, took prosecutorial decisions, managed and coordinated the investigation process, and that he was intimately involved in the prosecutorial process. At 184, I say, I did not accept this version in respect of the Mdluli matter for the reasons set out above. And 185, sorry, Counsel. 184.
Advocate Nkabinde, if I may ask a question, and I'm sorry, I'm going to take you back to paragraph 182, where the witness was supposed to show us that there was no evidence. And I'd like the witness to go back to SB3, page 226. Because that's where I think the team deals with their conclusion. The conclusion starts at 225.
225, Madam.
SB3.
SB3.
Yes, page 225, but I want us to go to page 226.
226, I'm there.
Yes, and if the witness can read paragraph 239 and explain her understanding of that paragraph.
Are you there, Advocate Batohi?
239.
Yes.
At
Yes, I'm
page
there.
226.
Requested by Madam Balohi Mere that you should read paragraph 239 on page 226. of
239.
Yes, 239.
After a careful evaluation of the evidence contained in the dockets, the pleadings in the various applications brought in this matter, we conclude that there was insufficient evidence placed before the acting NDPP, Advocate N. Jiba, and NDPP Advocate Abrams to justify the authorizations to institute a prosecution in terms of Section 21E and 21F of the Prevention of Organized Crime Act 121 of 1998. Despite the, sorry, should I continue to 240?
No, just enlighten me what you understand by this, the contents of this paragraph.
Yes. Having
and,
looked,
and in particular in relation to the no evidence principle.
having looked at the report in its entirety, I came to the conclusion that there was no evidence to support the racketeering charges. That doesn't mean that there's no evidence, but there's no evidence to support the racketeering charges. So I think it's important to make that distinction because the dockets contains statements, etc. But whether there's evidence to support racketeering charges is the question. And in that regard, having looked at the entirety of the report, I concluded that there was no evidence to support the racketeering charges. And as the panel puts it, they say there was at 246, in respect of both sets of authorizations, there were a proper case for racketeering was not made out on the papers presented. So that is the way I can explain the way they refer to not sufficient and insufficient evidence, and when compared to whether there was evidence to support racketeering charges.
Advocate Batohi, you read your paragraph 182, and then you referred us to this memorandum and in particular paragraphs to show that there was no evidence.
That is correct.
And to support racketeering charges.
That is correct.
And racketeering charges, if you may assist me, is in terms of Section
21E and 21F.
21F.
That's correct.
That paragraph 239,
yes,
deals with sections 21E and 21F.
That is correct, Chairperson.
And it talks about insufficient evidence.
That is correct, Chairperson.
So your submission, your overall submission is that you read this whole memorandum, and after reading it, you came to the conclusion that there was no evidence to support racketeering charges.
That is correct.
Despite the fact that the authors of the memorandum tells you that there is insufficient evidence. They are not saying there is no evidence. They say there is insufficient evidence. And then the paragraph that you just read now, 246, that a proper case for racketeering was not made out on the papers. But this statement, a proper case was not made out on the papers, does not mean there is no evidence.
Chairperson,
or is that how you understand it? That it means that there is no evidence?
I want to explain why I say that. If you look at the report in its entirety, and I want to highlight a few aspects from the report that will explain why I came to the conclusion that there was no evidence. And I would submit that the panel, in fact, also came to the same conclusion. Firstly, Advocate Sean Abrams, when he took office, he was not prepared to sign the POCA certificates, understanding that Advocate Jiba had already signed authorizations, I think in 2014. Advocate Abrams was not prepared to sign the authorization, and he wanted additional information. He wanted additional investigations. It was in 2015 that he was presented with a new memorandum. At this stage, he was still not satisfied. He then sent 2 staff members, Maema and another colleague, to Greece to get the statement of Danikas. When they returned, he said, and this is looking at his statement, I think he made before the Zondo Commission, but that is also an attachment to the de Kock report. Advocate Abrams' statement is attached. He says that when they returned, there was now considerable material before him when he issued the authorizations that did not serve before Advocate Jiba. The panel concluded at page 103 of the de Kock report that these were the statements and factors that he considered as the basis for the decision to authorize the racketeering prosecutions. And that's important. And they are the statements of that we've dealt with some of them. Colonel Ayer's further statements. He also referred to the ex-provincial Deputy Commissioner Brown's statement. He refers to the Danica statement, the statements of Mtiane, Matonzi, and Mkiz. And after studying, this is what he calls new evidence. Sorry, let me rephrase it. After studying the new evidence, according to Advocate Abrams, the panel concluded as follows. Firstly, the statements of Ayer and Brown were unable to assist the prosecution in proving that Boyson managed a criminal enterprise and or participated.
Sorry, where are you?
I've pulled out from the report, and I've just got some notes that I'm reading through at the moment to show that there was no evidence.
Which report? The one that is in front of us?
The de Kock report, that's correct.
You're now reading the conclusion?
No, I've taken out of the report some aspects to show why I concluded that there was no evidence. And I'm going through that, but it's from the report, but I've pulled them out and made separate notes, which I am going through now.
Through you, Madam Chair, maybe to assist the witness and Madam Baloyi Mere to answer the question and to get that maybe the required answer. Reference can be made to paragraph 190 whilst dealing with this issue of no evidence, insufficient evidence, and sufficient evidence. It might well be 190 of the internal memorandum of Advocate de Kock and others. Page 201, SB3. SB3, Madam Chair, annexure SB3 to Advocate Batohi's affidavit on page 201, specifically in paragraph 190. If you may read that paragraph 190.
Yes, thank you, Counsel.
190.1 and 190.2, that may assist you in answering the question.
Yes, thanks for referring me to this part. The heading of this section is concluding remarks on the racketeering offenses. 190, it is clear from our discussion that the prosecution will not succeed in proving the racketeering offenses for the following reasons. 190.1, there is no evidence to establish the existence of an unlawful enterprise separately from the existence of a pattern of racketeering activity. 190.2, the prosecution simply had several cases that they alleged established a pattern of racketeering activity and then attempted to show through the statements of Ayer, Danikas, Matonzi, Mkize, and Ndlolo that an enterprise existed. the case law is clear that an enterprise cannot simply be the undertaking of acts of racketeering. A racketeering indictment should focus on the entire enterprise rather than individual participants in specific acts. Should I read the entire 190?
No, it's enough up to there. I intercepted Madam Baloyi Mere with his questioning. She can then proceed.
Thank you.
But I just wanted you to have this in front of you when you are answering the question.
Thank you, Counsel.
What
And
is therefore relevant is 190, 190.1, and 190.2.
That's correct, Madam Chair. For current purposes.
I think perhaps if we look at 190.3, the statements do not, I think that no means should be not, prove that an organized criminal group existed that acted in common purpose and conspired together on a continuous basis to commit murder. I think given that the chairpersons asked specifically, I think if one looks at the rest of 190, I think it's also relevant for these purposes. And Counsel, maybe I should just quickly go through those as well. If
I think the witness should, because I'm looking at 190.6. So maybe it's better to read
Sure.
all those sub-paragraphs of 190.
Certainly.
Up to 190.6.
190.4, the statements do not prove that each of the managers in the criminal enterprise played a defined role in its operations and pursued their common goal to commit murders for profit on an ongoing basis as a cohesive unit. By simply choosing the managers of the enterprise according to the organizational structure of the South African police and the positions they held within their own units and or sections, the fallacy of this approach was exposed. Despite Mostad's alleged managerial role, the prosecution could not charge him since he was not a manager in the police. If one has reference to the evidence as contained in the, 190.6. If one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with the 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific threat of repetition extending indefinitely into the future.
So from this report, we are now told that it is clear from the evidence contained in the dockets that the alleged enterprise was on the verge of extinction.
What they are referring to there, they say alleged enterprise.
Yes.
And the enterprise that they are referring to would be the serious and violent crime unit of the police. And perhaps that was closed shortly thereafter. I can't remember. I can't recall. But that's what they're referring to.
I'm sorry, I didn't get that. You said the alleged enterprise would be?
The serious and violent crime unit of the police.
How do I differentiate between, because this is concluding remarks on the racketeering offenses, and it talks about an enterprise, but I don't see anywhere where it specifically refers to the unit that you referred to.
It is in the report, and as I've said, the entire report is in evidence. I'm just dealing with some aspects of it. If I can be guided, there is a section in this report that talks about the enterprise.
But before you even go further, let's read the 190.6 in its entirety. You can read it again.
If one has reference to the evidence contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific threat of repetition extending indefinitely into the future.
So that cannot possibly refer to the unit that you are referring to. It could possibly refer to the alleged racketeering enterprise, which evidence shows that in 2008 there were how many charges? 9, and then in 2011 there's only 2. Because if it were to mean the unit that you are referring to, then it would mean that you are actually charging the unit. But we are now here talking about racketeering charges, which we are told have gone. The charges have now reduced from 9 in 2008 to 2 in 2011. Not unless I don't understand this paragraph.
Yes, with all due respect, I think I need to explain the aspect of an enterprise in a racketeering charge, and that is dealt with in this report. Because you can have, in terms of the Act, an enterprise can be defined as an existing formal structure, which is, for example, a unit in the police, or the enterprise can be an association of individuals, in fact, a more informal structure. So what it was is dealt with in what the enterprise, how the enterprise was considered in this matter is dealt with. I'm not sure where it is, but there is definitely a section in this report that speaks to this very issue about how to define the enterprise. And this is an important aspect of racketeering.
Would it not be helpful to go to the definitions of the Act, rather?
Yes, it certainly will. But just it certainly will, Chairperson. We can do that. We have POCA, but in terms of how the enterprise was understood in this case, just to answer Madame Baloy-Mere's question about it being a unit in the police, it will be important to go to this, to the report. But generally, in terms of defining the enterprise, we can go to the Prevention of Organized Crime Act, which I have somewhere. It was in under. Oh, it maybe.
And when you look at 2.1.
If you bear with me, Chairperson. Thank you. Okay.
Yes, I was saying of relevance for this question could be the definition of enterprise. And you could also have regard to section 2 that deals with offenses. And then 2.1e and F, in which reference is made of managing, relevant to the Katomena issues.
That's correct, Chairperson.
To managing association with an enterprise or conducts or participate in the conduct directly or indirectly of such enterprise affairs through a pattern of racketeering activity. F, manages the operation within the context of the group or activities of an enterprise. And who knows or ought reasonably to have known that any person while employed or by association with the enterprise conducts or participates in the conduct.
Yes, Chairperson. If I may go to the definitions of enterprise first in section 1 of the Act.
Yes, ma'am.
Enterprise includes any individual, partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated in fact, although not a juristic person or legal entity. So the point being, you could have a formal structure or you could have an informal structure. And in this case, this aspect was dealt with, and I just want to try to find things, put the paragraph that deals with the enterprise. Did we get? I think it's page 152. Paragraph 152. I think it's paragraph 152. I beg your pardon.
Your affidavit.
No, it's of the report SB3. I'm just looking at that to make sure that I've got the right reference.
154 deals with the 23 dockets. Is that the one you're looking for?
No, not 154. No, Chairperson, I see at 152, it does, paragraph 152 at page 185. It does deal with the enterprise and its characteristics. It goes into the act which we had dealt with. If I could just read that carefully.
What paragraph is that, Council?
I beg your pardon, Chairperson.
What paragraph is that?
Paragraph 152.
SB3.
Yes, SB3, page 185. I'm just reading, Chairperson, to make sure that it is the paragraph I'm looking for. Here it's the more general. Look for it. I don't think that's this paragraph I'm looking specifically for, Chairperson. My apologies, but I'm trying to...
Advocate Batohi, 152 deals with an enterprise. Is that not the one that you're looking for?
Yes, it deals with the characteristics of the enterprise, but I was looking for a particular paragraph where the team was considering whether the enterprise being the serious and violent crime unit of the police.
Okay, maybe that what will help is maybe we should start at 70, paragraph 70, and then go to the organogram of the entity, Katomana unit, which is dealt with.
Okay, we have veered from my question. Can I bring us all back to my question?
My apologies, sir.
I wanted clarity on paragraph 190. Was it 190.6 on no evidence? Now we are bringing in a lot of things, but I want us to go back to SB3 page 135 and look at the purpose of this memorandum. If the witness doesn't mind reading the purpose at SB3 page 135 into the record.
If you bear with me for a moment. SB3 page
135.
The purpose of this memorandum is to provide the NDPP with an opinion as to the validity and the appropriateness of the decisions by the former National Director of Public Prosecutions, Advocate S. Abrams, and the acting National Director of Public Prosecutions, Advocate N. Jiba, to authorize a prosecution in terms of Section 2.4 of POCA Redwood, Section 2.1e and 2.1f in respect of the state versus Boyson and others.
That was the purpose of this memorandum.
Mm-hmm.
Now, what they say at at paragraph 190.6, and I wanted to okay, I wanted to right. I wanted you to look at it at paragraph 190.6 and paragraph 239, because when you started dealing with this document, you said you are clarifying the no evidence issue.
Mhm.
And when I went to paragraph 239,
Mhm.
you then said, okay, they said there is insufficient evidence,
Mhm.
but upon reading the whole
Mhm.
memorandum, you came to the conclusion that there was no evidence
To support racketeering charges.
to support racketeering charges. And when the whole memorandum was on racketeering charges, on the authorization on racketeering charges by both advocates Jiba and advocate Abrahams.
That was the purpose of the memorandum.
That was the purpose of the memorandum.
Correct.
And nothing else. Now, paragraph 239 tells us that there was insufficient evidence to support the authorization in terms of 21E and 21F.
Mhm.
And then you then read 246, which says, in respect of both sets of authorization, a proper case for racketeering was not made out.
Mhm.
And it was when I asked this question that does not, if papers are submitted, but they do not make out a case to support or to result into a positive order given.
Mhm.
Does that mean that there was no evidence at all? And then we went to then 190.6, which then spoke about an enterprise that was an alleged enterprise that was on the verge of extinction. And then that's where you said the enterprise might not mean the racketeering issue. It might mean, what did you call the cattleman? You called it
The SVC. Serious and violent
serious
crime
and
unit.
violent crimes. And that's when we started talking about the enterprise. And when the proper reading of the definition of enterprise, and also when you look at the purpose, the purpose was not to investigate the SVC, serious and violent crimes. It was to investigate whether there was a reason to issue authorization certificates for racketeering. So, can I conclude by saying, can we agree that after reading this, you came to your own conclusion that there was no evidence, despite the fact that in some instances, the authors of the memorandum tells you that there was insufficient evidence, and we know what insufficient evidence means.
Okay. So I can't agree with your last question, and I've got to explain why. Firstly, There are several comments that you made in the course of getting to the question that I need to comment on. For example, the purpose was not to investigate the SVC, but to investigate racketeering authorizations. Now, the whole point here is that my understanding is what the team was saying is that the SVC is the enterprise. That is what I was trying to find, that part in this report that actually talks about how the enterprise is defined, how the team was attempting to define the enterprise. So this is a very technical, highly technical issue, and it's important that I be permitted to explain. And I've been taken on tangents. So I was actually trying to explain the evidence, no evidence, and I had this document that I'd selected parts from this report, and I was trying to go through that to show that my conclusion that there was no evidence was based on those things. And then I got like a third of the way, and then we went to the act, we got to enterprise, and I'm trying to answer the questions, but we do get sidetracked. But now I'm coming back to your question, which has a lot to it. So I need to explain a few things. Firstly, I'm hoping that paragraph 149, which my colleague says to me might help, is what the paragraph that I'm looking for that will clarify the issue of SVC and the enterprise.
Paragraph
149, but I'm checking myself to make sure it's the correct one. No. No, I don't think that's the paragraph I'm looking for. Chairperson, the point I was trying to make, and maybe I'll find it later in this document, is that the team, in order to prove racketeering, you have to prove that there was an enterprise. An enterprise can be a formal structure, like a unit of the police with a formal command structure. Or an enterprise could be a more informal structure where there are individuals that are, as the Act states, associated in fact. But it's a more of an informal arrangement, but it's nevertheless has a kind of structure where you have a manager and you have others that participate and play different roles in the enterprise. In this case, my understanding is that the team that were proposing racketeering charges were actually defining the enterprise as the serious and violent crime unit, a formal structure in the police. And that is the relevance of that unit to the charges relating to racketeering. So I'm just trying to think how to structure my response. 152.1. Let me check 152.1, Chairperson, if you'll bear with me. I'm checking 152.1. So 152 and it states an enterprise is characterized by its members having a common or shared purpose, where there is some sort of hierarchical decision-making structure and where the enterprise is ongoing with some continuity of personnel. The Prevention of Organized Crime Act 121 of 1998 does not define who is a manager. 152.1. In respect of who the managers of the enterprise were, the prosecution charged the accused according to the organizational structure of the South African police and positions they held within their own units and or sections. Boyson was charged as a manager, since he was the provincial commander, organized crime KZN, and later on the provincial head, DPCI KZN from 2010 onwards. Olivier was the section commander of the section, while Lockham and Van Tonder were group commanders in this section, whilst all the others under their command were charged in section 21E. So that is why I was talking about the SVC being the enterprise that the team was saying was the racketeering enterprise. I think 152.1 actually does address that. I'm just looking at the other paragraphs that follow.
Advocate Batohi, I'm sorry to interrupt you. I don't think you and I are at loggerheads with what you are saying.
Sure.
I think we agree.
Mhm.
We agree about an enterprise, not and we agree that what you've just read, that Boysens was charged, he was deemed to be the manager of the enterprise because of the position that he held. That I'm paraphrasing, but I hope I'm correct. I'm quoting you correctly. And the other person, Olifir, was considered to be a manager because of whatever position he had. So that doesn't differ from what I'm saying. All I'm saying is the purpose of this memorandum was to deal with the enterprise and was to deal with the authorization certificates by both Advocate Jiba and Advocate Abrams. And somewhere in this memorandum, they say they mischaracterized the two police officers as managers of an enterprise, and also they approached the two heads of NPA with insufficient evidence while seeking authorization certificates for racketeering. Should I repeat the last portion?
No, I heard it.
Yes. So I'm saying you and I think we are on the same page, except only that you, after reading this whole memorandum, you came to a conclusion that there was no evidence at all. I will leave it at that.
No, I'm considering my response to that.
Oh, okay.
No, sorry, my apologies. I'm just reading your question before that because I want to make sure that I respond correctly. So I'm reading about your comments that you say they mischaracterize them as managers. Are you referring to the authors of the report that mischaracterize them?
The authors say the applicants for the authorization of the racketeering certificates, and that's the paragraph that you just read. I think 152.1. Because they say they charge the accused according to the organizational structure of the South African police. I'm saying maybe they mischaracterized. They read or they assumed that they are managers of the enterprise based on the positions that they held within SAPS.
So maybe so it's not the authors. Sorry, that's fine. Okay, but it's the team.
Applicants.
Understood.
The team, yes.
Understood. Chairperson, yes, we can only surmise about what they thought when they looked at the evidence. So I can't comment on that. But what I do want to say is that I was trying to answer the question at the outset about why I came to the conclusion, correctly as you say, having read all of this, having read the report, considered the evidence, as well as the Govan judgment, that there was no evidence to support racketeering charges. And I do want to state specifically that in that regard, we have a situation where we have the key statements that both Advocate Jiba and Advocate Abrams say they relied on to come to the conclusion that they could authorize racketeering, were statements that we've dealt with. And in terms of dealing with the additional statements that Advocate Abrams said he got, the statements of Ayer and Brown were not able to assist the prosecution in proving that Boyson had managed a criminal enterprise or that he participated in the affairs of the criminal enterprise, which Advocate Abrams had actually took those statements to prove that. Well, maybe with other things as well. But the Danikas evidence, this was unsworn statement. And I do want to refer to our policy directives that deal with whether, and I was asked a question some time ago about whether information or evidence that's not sworn can be considered. And I want to specifically refer to our policy directives. I think it is that deals specifically with this aspect.
Yes, Advocate Batohi, they are not part of the record.
Okay.
We will then ask that they be handed up as exhibits.
Thank you.
Madam Chair, with your permission, the policy directives are not in the bundles. It's only the code of conduct and the prosecutorial. They have the policy directives. And they will later be marked as exhibits accordingly. And I'm giving my colleague 2 copies.
It's the policy itself.
This is part of the policy directives.
Where's the policy?
This is a part of the policy directive that runs from part 4. Is it deliberate that you're giving us only these pages?
I had to look in the
It is deliberate. These are the pages that those copies I have, which have been given to me by the NPA team.
May we have a complete document at least? How big is this document? I've read somewhere Pardon?
Please can you find that?
I've read somewhere where they refer to certain portions of policy directives, but I'm not sure whether that is confined only to part 4. Otherwise, we'll have a piecemeal referral to this document, and it may end up being marked differently at a later stage.
Madam Chair, I'm informed by the NPA team that yes, it is deliberate, but the witness will explain why it is as it is now.
And this document is in relation to which point, which my sister was asking? Is it connected to those issues that have been raised regarding the no evidence?
It is connected, Madam Chair.
It is connected.
Yes, it is connected, as well as the withdrawal by prosecutors, institution of prosecutions. It deals with that.
Yes, I just want to make some.
Advocate Batohi.
Yes, my apologies, Chairperson. I'm trying to find the document. Firstly, I should perhaps deal with the policy directives that we've handed in. Chairperson, the policy directives are confidential, is a confidential document. It's not made public. And this document, so what we've done is we have, I have obtained permission from the Executive Committee of the NPA to disclose these parts of the policy directives. I think it's about a 150-page document that relates to specific aspects that have been canvassed in this inquiry, and that is part 4 that deals with institution of prosecutions, part 5 that deals with withdrawal of cases and stopping of prosecutions, and part 6 that deals with representations and reasons for decisions. Chairperson, but I am looking specifically to go back to where we were. I was dealing with the fact that there was no evidence, and I said that the issue of sworn statements, there is in one of our directives or the policy itself very clear direction that it is only sworn statements that must be considered as evidence before a decision to prosecute is taken. I'm going to find that, and we will then refer the panel to where exactly that can be found.
Madam Chair, I'm alerted to the fact that it is lunch break.
It is a lunch break, and I must check first with my sister whether she is done with her questions.
I am done, but I wanted to ask Advocate Batohi to consider something while on lunch. Can you you keep on referring to, is it Danika's statement that was not deposed to? Can you look at it and also read section 2 of the Poker Act, subsection 2, and advise us on how that is dealt with and whether your policy directives can trump what is contained in the Poker Act in section 2, sub 2.
Certainly can't trump an act, but I'll have a look at it and see how
Please.
it works
Thank
together,
you.
perhaps.
Chair, thank you.
We adjourn in relation to this aspect of the no evidence. I'd like you to look at paragraph 143, SB3 183 at paragraph 143, and clarify what we should make of this statement.
Chairperson, if I've got that right, SB3,
SB3 183 at
Is that-
paragraph 143.
page 183 at paragraph
143. The admission made by General Boyson of his presence at the scenes. And I'm raising it in relation to the no evidence as regards the racketeering charges.
Certainly,
So
Chairperson.
you can
Chairperson,
reflect on that, and you may address us when we reconvene.
sure. We have found the policy, but I'll deal with it after lunch.
Yes, thank you. Let's take a lunch adjournment. It's now 10 to 2. I've conferred with my sisters who will have an hour lunch break until 10 to 3. We adjourn.